Social media is operative.
Yeah.
Okay, great. We have everybody in the room. Well, good morning, everyone, and thank you for coming. I'm Father Frank Pavone, National Director of Priests for Life, and I'm joined here by Janet Morana, our Executive Director, David Yerushalmi, who represents us in this case, together with Robert Muse of the American Freedom Law Center, and Dr. Alveda King, our Director of African American Outreach. Both Alveda and Janet, along with me, are plaintiffs in this case, along with our organization. Priests for Life, the largest ministry in the Catholic Church focused exclusively on ending abortion, is happy to welcome you to this press conference regarding the case Priests for Life versus the HHS, which the Supreme Court has accepted, along with 6 other similar cases, which are the Little Sisters of the Poor, the Archdiocese of Washington, the Diocese of Pittsburgh, East Texas Baptist University, Southern Nazarene University, and Geneva College. The cases challenge the HHS mandate, which tries to force groups like ours to cover abortion-inducing drugs and other services we find morally objectionable in the health insurance coverage we offer to our employees. This press conference will attempt to explain as plainly and simply as possible to the public what's at issue here and what are the arguments on each side. Let me say first what this case is not about. This case is not about making contraception illegal. And although our organization does work to make abortion illegal, that is not the point of this case either. Nor is this case about forcing our employees to adhere to our religious beliefs. It is about the freedom of us as employers to practice our own religious beliefs, not just in church on Sunday, but in the workplace on Monday. Neither is this case about simply an objection to paying for objectionable health insurance. Even if the case were convincingly made that the objectionable coverage does not cost us a penny, our objection would still be there, because we as Priests for Life are still the gateway by which our employees would receive the objectionable coverage. What makes this case hard to understand for many is that the government has in fact offered all of us plaintiffs an opportunity to opt out of the obligation to provide insurance coverage for these objectionable services. All we need to do is fill out a form or write a letter, and we are, according to the government, off the hook. So what are we objecting to? We are saying that not only does it violate our faith to offer the objectionable insurance coverage, but it also violates our faith to even fill out that form or write that letter. Why? Because according to our sincerely held religious and moral beliefs, even those actions make us, in a moral sense, a part of the process by which the objectionable coverage will be offered to our employees anyway, once the government and the insurance provider see that we've filled out the form. And our religion does not allow that kind of cooperation or involvement. Put simply, filling out this form is a necessary part of the process by which the Obama administration is expanding coverage for abortion-inducing drugs and contraceptives. Were it not part of the process, the government wouldn't require us to fill it out. And we don't want to be any part of the process at all. Our message to the government is this: if you want to provide the services to which we object, you're going to have to do it without us. Now, some people may think these beliefs are ridiculous, overly scrupulous, or unreasonable. Others, including the judges who ruled against us in the lower courts, claim that we have misunderstood and misrepresented how these government regulations operate, and that we are not, in fact, part of the process to which we object morally, and therefore that the government has already done all it needs to do to accommodate our religious freedom. But here's the point. The role of a judge is to make judgments about law, not about religious beliefs. It is beyond the authority of the courts to tell Priests for Life whether its beliefs are accurate or reasonable or overly scrupulous. People are free to think that they are. But those people are also free to think that something that we say is inaccurate or unreasonable. Yet the courts still have to protect our freedom of speech, even in those instances. So too must the courts protect our freedom to believe and practice a belief, even though some find it unreasonable. Whenever the government punishes a believer for practicing some aspect of his faith, that's a substantial burden on religious freedom. And in this case, we would face tremendous fines for not following the dictates of the HHS mandate. A nation that says, violate your faith or pay a price, is not protecting religious freedom. And in fact, federal law in the Religious Freedom Restoration Act, or RFRA, protects that freedom and prohibits that kind of punishment. Now, the government is going to claim in this case that expanding access to abortion and contraception is so important a goal, in legal terms, a compelling interest, that it justifies restricting our religious freedom in this instance. But RFRA says that even if the government's interest is compelling, it can only substantially burden our religious freedom if it uses the least restrictive means to do so. And we say the government does have, and therefore must use, less restrictive means to provide our employees the insurance coverage for services to which we object. Why do you have to have us involved in the process at all? By filling out this form, we are notifying our insurance provider that they need to take additional measures to cover our employees for abortion and contraception. Our moral convictions do not allow us to do that. We want no part of it. Can't the government arrange for the employee who wants the additional coverage to let the government know that independent of any action of the employer? That would be far less restrictive of our religious freedom. In fact, it would not restrict it at all. Notice that this is not about paying for the coverage. Our objection is that employment with Priests for Life would still be the gateway through which our employees would have access to the objectionable coverage. It's not simply about payment, it's about involvement in the process. And this is also not about objecting to what someone else, whether it be the government, the insurance provider, or the employee, is going to do. Some court decisions have misrepresented this point. Our objection is not about what someone else is required to do or might do. It's about what we, the employers, who have sincerely held religious beliefs, are required to do here and now. And this is not about imposing our religious and moral beliefs on our employees. It is about being prevented as employers from living out our own religious beliefs and conducting our business affairs according to our own moral convictions. Nobody is forced to work for Priests for Life or for any of the other plaintiffs. Moreover, if they choose to utilize these objectionable services, they're not deprived of any employment benefits. As it stands, in fact, though, all of our employees are completely in agreement with this lawsuit and have applauded it ever since it was first filed 3.5 years ago. I'm delighted that Priests for Life is in the Supreme Court, and I'm delighted that 7 national organizations, whom I also want to mention here, have filed a friend of the court brief, which, when the Supreme Court granted cert in this case, it also accepted this friend of the court brief. Those associations are the Association of American Physicians and Surgeons, the American Association of Pro-Life Obstetricians and Gynecologists, the Christian Medical Association, the National Catholic Bioethics Center, Alabama Physicians for Life, the National Association of Pro-Life Nurses, and the National Association of Catholic Nurses. They too are happy to be with us in this case, with the other 6 cases that have been consolidated with ours. We're happy to be in the Supreme Court, but we're saddened that it's necessary for us to be there. We know we're on the right side of these arguments, and I believe we will win this case. Those are my opening remarks. I have brought for you also this diagram to explain what I just did say. The first instance represents a situation where the employee would have some arrangement to go directly to the government to get this additional coverage for the objectionable services, would leave us completely out of it. That would not involve us, therefore that would satisfy our objections. The middle part of this diagram is the unacceptable situation we're in right now, which is that the coverage, and I say abortion coverage because there are abortion-inducing drugs and also contraception, sterilization, and so forth, all of which we object to. This coverage is being offered to our employees because of the connection and involvement of Priests for Life. Again, not simply a question of payment, it's involvement in the process. The third part of the diagram here is what we in fact have been doing and want to continue to be able to do, and that is that the employee having health insurance precisely through their employment with us has coverage without abortion and the other objectionable services. So hopefully this diagram will help to spell out arguments which very often in these cases have been misunderstood and misrepresented even by some of the courts. I mentioned David Yerushalmi, who is here. He and Robert Muse head up the American Freedom Law Center, and from day one they have been involved with us in this case, and I would like to invite David now to make some remarks, and he and all of us will also be available for some questions at the end. David?
Thank you, Father. I'll keep my remarks short because Father Frank did a remarkable job as a head of the organization in laying out the legal case that is before the Supreme Court. Principally, though, what's important to keep in mind is this is not a constitutional case. Under the First Amendment free exercise clause, over the years, the court had begun to whittle free exercise down. Congress responded and passed the Religious Freedom Restoration Act, RFRA. RFRA is the battle that we're fighting here today, because what it says, as Father Frank articulated in the context of the facts of this case, are as follows. 1, you cannot impose a substantial burden on someone's religious practice. 2, if you do, you better have a compelling state interest. And if you have that compelling state interest to impose a burden on religious practice, it better be, 3, the least restrictive measure possible to achieve that compelling state interest. We argue, and the case Priests for Life versus the HHS, which is one of 7 cases, is actually one of the best cases to be before the Supreme Court, and we believe could very well be the focus of the Supreme Court. Indeed, the Solicitor General himself, in his brief to the court, argued that this case would be the best case to focus on. Why? Because the court below in the District of Columbia addressed all 3 of those issues. Many of the other cases, the court simply said no substantial burden. The final point I want to make here, and it's important, is that the case law is clear that judges have no place in deciding what is a substantial burden on someone's religious practice. If it's a sincerely held belief, the judges, as secular arbiters of the law, have no business trying to decide if signing a form or any other activity that triggers contraception, abortifacients, etc., would be a substantial burden. The cases that have decided an opposite, our District of Columbia case, for example, that held that it was not a substantial burden, are simply flying in the face of court precedent that goes back decades. One final point, as a kind of postscript. Father Frank identified many organizations, and Priests for Life is distinctly a Christian organization, obviously Catholic. I'm here today, my colleague, partner, and founded American Freedom Law Center is a Roman Catholic, devout. I'm here today specifically to say that this isn't a Christian issue simply. Jews, and I presume other people of faith who take seriously the life of the unborn and their religious obligations, their personal, deeply felt religious obligations, stand with us as well. I'm here not just as a lawyer, I'm here as an advocate on behalf of the positions maintained by Priests for Life.
Thank you, David. I'd now like to introduce Janet Morana, who is the Executive Director of Priests for Life and a personal plaintiff in this case as well, to make some remarks. Janet?
Thank you, Father. Well, as Father said, the women of Priests for Life, our employees, all stand with us, and I can tell you that personally because since day one, we have spoken about this. When our employees are hired, they are clearly told about our insurance coverage, that it does not include contraceptives or abortion, and they're fine with that. So before they're even hired, they are told quite clearly. Anyone also that comes to work for Priests for Life knows our primary mission is to hold up the church's teaching on abortion and contraception. So before coming to work for us, they understand these things. But myself as a woman who actually years ago, decades ago, took the contraceptive pills, saw the physical damage it did to me, and also in my research for my book, Recall Abortion, I have a whole chapter on what this pill, pills, the contraceptive pills do to a woman physically. And for example, one of the pills that is popularly dispensed these days is Yaz and Yasmin, produced by Bayer Pharmaceutical. And to date, there have been over 6,000 lawsuits by women who've been either physically damaged or families bringing forth lawsuits of women who were killed by taking Yaz or Yasmin. And to date, Bayer Pharmaceutical has paid out $1.4 billion in settling these lawsuits. And there's more to follow. So as the person who has to sign off on providing this coverage, like they both said, it's morally objectionable, but I also take a stand for the women. Why would I want the women under our employment to be physically damaged, knowing the facts that I know? And so therefore, I hope that we are successful. I do believe we will be because, again, we're standing on good, sound principles, and we have a wonderful team of lawyers to assist us. And also, too, what happens to us will affect so many other groups who have lawsuits currently all over the country at the federal level. So this is a very, very important battle we're in, and we hope that we'll all join us in prayer so that we could be victorious. Thank you.
Dr. Alveda King heads up our African American outreach at Priests for Life, and she too is named as a personal plaintiff in this case, and I want to invite her to make some remarks.
As Director of African American Outreach for Priests for Life and a post-abortive mother who has experienced the pain and harm of contraceptive agents such as shots, pills, and devices, I joined several women employees, and as Janet has stated, all the women employees of Priests for Life in standing against any implied or otherwise open participation with any aspect of the HHS mandate. I stand with Priests for Life, which includes Father Frank Pavone, National Director of Priests for Life, Janet Morana, Executive Director of Priests for Life, and myself. The HHS mandate infringes upon my rights as a woman, my religious freedom, my civil rights, and my health and well-being. Understanding that the U.S. Supreme Court speaks and rules from a position of common law, which is human law, and operating under a measure of authority to govern. In America, theirs is the highest rule of law that humans can make. Yet the rule of the USSC is not the final word. In the end, natural law, God's law, will always trump common law. Do not fear or be confused or deceived. Remain prayerful, keep looking up. God will have the final word in this matter. Therefore, I must encourage listeners in this manner. Don't be misled. You cannot mock the justice of God. You will always harvest what you plant. Let not your heart faint and not be fearful at the report heard in the land when a report comes in 1 year and after it a report in yet another year, and violence is in the land and ruler is against ruler. As to the decisions before us regarding the HHS mandate, in contrast to God's law, the civil laws and common laws of our nations are not written on anybody's conscience of mind. They are not written in the physical creation, nor are they appended in the Bible. The civil laws of nations are only written in their own law books. Consequently, the validity and force of such laws are based solely on national authority. There is no other supporting evidence or witness to testify to the validity of specific civil laws. Consequently, In order for the civil laws of any nation to be authoritative, they must at least be supported by the testimony of another source, and that they are consistent with God's delegation of authority to civil governments. This is more thoroughly explained in Romans 13. Let every soul be in subjection to the higher powers, for there is no power but God. And it goes on to explain that if you have time to read it. In order for the laws of a nation to be valid, they must at the very least, harmonize with and not contradict the law of God. We know the law of God by looking into its expressions. If the laws of a nation conflict with one of the expressions of the law of God, then something is amiss. Or perhaps we do not understand one or the other very clearly. Unfortunately for women, the HHS mandate does not conform to this formula, which is why I stand with Priests for Life in the complaint against the HHS mandate. Thank you.
We'll now have time for some questions. Yes.
Two questions. First one is, I forget which judge it was, I think it was Sixth Circuit, but I could be wrong, who said that because the insurance companies are already mandated to provide this kind of coverage, signing the paperwork would not add an additional burden to any organizations opposing the mandate. I wonder if you had a response to that.
I want to let David address that, but I'll simply add this comment that the way that the process works legally has to be distinguished from the way it works morally. A judge may say to us, you misunderstand the law, but we do not misunderstand our moral obligations, and we are saying that religiously, the way that the ethics of cooperation and non-cooperation in evil, our faith doesn't allow us to do it. But again, that has already been a dispute between the judges that ruled against us in the Court of Appeals for the D.C. Circuit and what our stance continues to be. But David?
Just briefly, keep in mind that while insurance companies are mandated to provide coverage, the only way they will provide that coverage for the employees of Priests for Life under the mandate is if Priests for Life does something. They have to fill out a form and trigger that coverage. That triggering is, as Father Pavone indicated, a participation in and a facilitation of the objectionable conduct.
Follow-up question to that, if I may, is that President Obama, when the mandate was first introduced, he said that this would save women $720 a year on average. Where is the government's compelling interest in making sure that women don't get pregnant from sexual relations?
It's interesting, because if you look at the way the HHS mandate, ObamaCare's mandate operates, religious churches are exempt.
Go ahead.
There are all sorts of exemptions that apply. In addition, nothing stops the government from simply offering the coverage here. Simply going to the women and saying, if your employer doesn't provide the coverage, then just walk over to the window at your neighborhood government office and get the coverage. If it is a compelling interest, and we'll leave that question for the government to tell us it is a compelling state interest. What we do know, it is a substantial burden, and if it is a compelling interest, this system right here is not the least restrictive by a long shot, because there are so many other ways that the government now exempts certain individuals and organizations and could provide the coverage without involving Priests for Life.
Can I ask one question on that, just as a follow-up? If indeed the mandate did say $720 or an estimated $720 for women, how would the mandate pay for all of the other issues that are linked? Janet's book and much of our research shows this, to breast cancer, cervical cancer, strokes, heart attack. The existing HHS mandate is more expensive than they promised and is not covering women adequately. So that is a disservice to dangle a carrot and say, we'll save you $720, but we're gonna cause you pain, suffering, surgery, death, strokes, heart attacks, etc. So have they factored in that care in the formula by suggesting, and it's very insulting to say, we'll save you $720, but we'll give you breast cancer, cervical cancer, strokes, heart attacks, frustration.
Let me also point out the danger of President Obama's argument, as you so well summarized. When this mandate came out, and we first saw it in the beginning of 2012, and the list of preventive services that have to be covered under it was made, there was on that list the abortion-inducing drugs, contraceptives, sterilization, and other things. If the government were to win this case, what is to prevent them from putting anything else on that list? And what is then to make to prevent them from making an even stronger argument about how much money would be saved? Imagine then if on that list were abortion on demand throughout pregnancy. What about euthanasia? What about the argument that, well, if you just cover the cost of a lethal injection for someone who wants to commit physician-assisted suicide, look at all the money in healthcare costs in the later stages of a terminal disease that we will save. It is a dangerous argument, dangerous to human rights, dangerous to conscience, dangerous to the very survival of the nation. Other questions?
I'd like to ask the distinction of filing on behalf of Priests for Life, and all three of you are also filing personally. You mentioned some of the personal reasons for that, but David or Father, can you explain why also they're filing individually as persons?
Well, it's obvious why Priests for Life as an organization files, but because each of these individuals, an organization, a corporation, is still made up of individuals. It's a fictional person. Someone on this podium has to sign the form. It imposes an obligation on the individual executives of the organization.
And I won't sign the form.
Amen.
I said that in federal court, by the way. You know, in federal court, David and Robert were down there arguing the case, and I was up in the gallery with Father Pavone, and the judge was questioning them over, you mean this? They will not do this? And I'm going, and I'm shaking my head like this, and the federal court judge said to them, your client is agreeing with what I'm saying. So absolutely, I will not sign those forms. And as the executive director, I would have to be executing those forms. So that's a real compelling reason why I have to be a plaintiff in this case.
And then the follow-up is, what then will be the fines if you don't fill out the form? What are the fines that you're facing?
The fines, I think, go to the, maybe you can answer that.
The fines themselves go to the organization.
Right.
And do you know what those would be? They have 50 employees.
Well, they're substantial, and they're substantial over time. I don't have a calculation here today, but they, for an organization this size, they are substantial.
Is it $100 per day per employee? Is that the number?
Mm-hmm. Something like
Per
that. Yeah.
employee.
Yeah.
Yeah. So.
Any other questions? Well, I see a number of my colleagues in the pro-life, pro-family movement, together with our friends from various media outlets here. So again, we're encouraged by your presence. We thank you for covering this story. Looking ahead, as soon as we get the date when the oral arguments will be heard at the Supreme Court, presumably sometime in March, we will have both a press conference and a major rally outside of the court. And we expect at that time to have, as we did when we had the oral arguments in the Court of Appeals, a large representation of national pro-life, pro-family leaders, political leaders, even some of the presidential candidates we expect will be there at that time. And we will have remarks then after we come out of the court with our reflections on how we believe the oral arguments went. On that day, when that does get announced, we will also obviously be involving the other plaintiffs from these other 6 cases, and so we expect to have a rather major event on that particular day. In the meantime, we appreciate you covering this story as it unfolds, and the website, as you see on this poster, istandwithpfl.com is the place where we will keep not only detailed updates about our response to the case, but also all the documentation that will come out, all the filings and briefs, etc. And you'll find there all of that kind of documentation for the case as it has progressed up to this point. And so I invite you to use that as a reference point. We will also have there prayer activities. We have a prayer campaign in conjunction with all the legal action. And both the prayers for the prayer campaign and also the action we're encouraging individual believers to take in union with this case are all explained there on istandwithpfl.com. We will be available for individual interviews if you like for at least a little while here. And again, I thank you for coming and thank you for your commitment to these issues. God bless you.
Question.